Hello everyone. Today we are going to start with the past year papers of All India Bar Council examination, and we are starting with 2012. So before I start, I'm just going to run through the instructions which are going to remain common for all of the papers. So this is a 100-mark paper first of all, right? So each question has 1 mark and therefore there are 100 questions. And then each question has 4 options and there are multiple options, but you have to choose one correct answer. And the good part about this paper is that there is no negative marking. As we all know, this paper is sort of like a qualifying exam. There are no marks per se. It's just passing this exam, which would in return get you your license. Further, this exam is of 3 hours. And all the other instructions are very common, which we already know that we can take books. So, abhi ke liye, it is an open bare act exam and not open book exam. So, therefore, according to me, in my opinion, you are not allowed to take, other notes as such, but you can obviously take your bare acts without comments. And there are certain exceptions if the barrack without comments is not available, then they will also allow you to take some barracks which have short comments in them. And other than that, you have to use either blue or black ball pen over the OMR sheet. Right. So now let us quickly start with the first question, which is who categorized the subject of jurisprudence as expositorial jurisprudence and sensorial jurisprudence? The right answer over here is Bentham. So these are few common questions which we should know because there won't be any bare act which would give you the answer. So it's always better to solve some past year papers and be up to date for that. Then let us start with the second question. Who described jurisprudence as lawyers' extra vision? And the answer is Julius Stone. Fiction theory is related to which of the following concepts? Legal personality. The Consumer Protection Act was enacted in the year 1986. This is something which you can get from your Bear Act. Appeal against the award of claims tribunals under the Motor Vehicles Act 1988 can be made under. The right answer is section 173. Again, we will be able to find this particular answer in our Bear Acts. The amendment in Motor Vehicles Act in 1994, the compensation in case of death of person is, the right answer is 50,000. Under vicarious liability, the liability is, it is both 1 and B. So what is 1 and 2? That is joint and several. So we all know vicarious liability में liability joint और several दोनों होती है. In torts, in case of defamation, and then the right answer over here is intention to defame is not necessary, right? And यहाँ पे जो options है, both A and 1 and 2. Obviously, this is not right because if you see the options itself, even though यहाँ पे आपके पास torts की कोई whereas नहीं होगी, लेकिन it is very obvious that both the answers can't be and either A or B का भी सवाल नहीं आता है because here they are talking about something which is very specific कि ये होगा या तो नहीं होगा. तो ये both भी नहीं हो सकता, either भी नहीं हो सकता, and because we have studied torts in our LLB, we know that intention to defame is not necessary. Then, when was the Advocate Act introduced? This is fairly simple. This was 1961. The Bar Council of India consists of following as ex officio member, and here the right answer is Attorney General of India as well as the Solicitor General of India, and that is why the correct answer is both A and B. So the Bar Council of India consists of following as ex officio member, and that is Attorney General of India as well as the Solicitor General of India. Then Indian Bar Committee was constituted first time under the chairmanship of Sir Edward Camier in the year, the right answer is 1923. तो जो इंडियन बार कमिटी थी वो फर्स्ट टाइम 1923 में कॉन्स्टिट्यूट हुई थी एंड अंडर द चेयरमैनशिप ऑफ सर एडवर्ड कैमियर हो सकता है, ये भी उल्टा भी क्वेश्चन आ सकता है that under whose chairmanship was this committee constituted. In that case, the answer is Sir Edward Camier or Chamier, however his name is pronounced. Then power of disciplinary committee under the Advocate Act is provided under Section 42. Indian Council of Arbitration was established in the year 1996. Lex arbitri means arbitral tribunal sitting in India can apply the by of the Singapore. I am not sure what this reads as, whether this is correct, but the answer over here, according to the answer key, is going to be A. That is, arbitral tribunal sitting in India can apply the by the Singapore. Maybe the sentence formation is something which is wrong, so we can check this. Then question 15 is in India, the Arbitration and Conciliation Act was enacted in the year. This is very easy. This is 1996. Section 10, subsection 1 of the Arbitration and Conciliation Act talks about number of arbitrations. A Sunni Muslim marries with Kitabia girl. The marriage is valid. The dissolution of Muslim Marriage Act 1939 is based on which school of Muslim law? Here the answer is Maliki schools. Now questions like these, which are based on maybe Muslim law or law of torts, these are things which you might not find in your Bare Act, even jurisprudence for that matter. तो इसके लिए ये जो past year के papers के questions है उसे solve करना बहुत जरूरी है, because this is the only way you will be able to understand what kind of questions come from these subjects. So therefore, the dissolution of Muslim Marriage Act 1939 is based on Maliki school, right? So option C. Under Hindu Adoption and Maintenance Act 1956, a female Hindu has the capacity to take a son or daughter in adoption if if she is not married. So यहाँ पे there are few things which are to be noted. Now obviously इसका answer की के according A है, लेकिन if we know that there was an amendment by virtue of it, female Hindu can adopt, and वो जो same provision male के लिए है वो same provisions female के लिए भी apply होते हैं. तो यहाँ पे in case अगर ऐसे होता that if she is married and she's taken the permission of the husband, तो भी वो answer जो है सही होता. So for things like that, you have to verify. If you're referring to papers which are quite old, it is always ideal to, verify your answers. Let us move ahead with 20. A child born of void and voidable marriage under Hindu law is legitimate, right? Legitimate, this is very basic. Then the father of which of the leader has been the deputy prime minister of India? This is again legal GK. This is Mrs. Myra Kumar. Answer is B. The father of which of the leader has been the deputy prime minister of India? Mrs. Myra Kumar. Who was constitutional advisor to the Constituent Assembly of India? The answer is B.N. Rao. Constitutional advisor to the Constituent Assembly of India was B.N. Rao. The concept of judicial review in India is based on, the answer is international treaties and conventions. Then protection of environment is बी भी है, सी भी है, डायरेक्टिव प्रिंसिपल भी है और फंडामेंटल ड्यूटी भी है. 25 इज द आइटम एजुकेशन बिलोंग्स टू दी, ये आपको कॉन्स्टिट्यूशन की बैरक में भी मिल जाएगा, बट वी नो दैट दिस इज कॉन्करेंट लिस्ट बिकॉज स्टेट और यूनियन दोनों ही एजुकेशन के ऊपर लॉज बना सकते हैं एंड इसीलिए ये कॉन्करेंट लिस्ट में आता है. While interpreting the phrase equality before the law contained in Article 14 of the Constitution, the Supreme Court constantly maintained that equality means, then these are your options, and the correct answer is among equals. The law should be equal and should be equally administered. Therefore, the right answer over here is C. The number of fundamental rights available in the Constitution of India are 6. फंडामेंटल राइट्स अगर आप देखें तो ये कैटेगरीज की बात कर रहा है ना. ऑब्वियसली वी नो कि आर्टिकल्स 14 से लेकर 32 तक फंडामेंटल राइट्स होते हैं. सो वी आर नॉट गोइंग टू सिट एंड काउंट कि 1 2 3 4 5 6. हमें कैटेगरीज देखनी है. द फंडामेंटल राइट्स आर कैटेगराइज्ड इनटू 6 ब्रॉड कैटेगरीज एंड दैट इज द राइट आंसर एंड दैट इज व्हाई द आंसर ओवर हियर इज 6. Then question 28, which one of the following fundamental rights was described by Dr. B.R. Ambedkar as the heart and soul of the Constitution? And the right answer over here is rights to constitutional remedies, जो हमें Article 32 के अंदर मिलता है in case of Supreme Court and 226 in case of High Court. What is the period of appointment of the Comptroller and Auditor General of India? And the right answer over here is 6 years or 65 years, whichever is earlier. Which of the following writs is a bulwark of personal freedom? And here the answer is habeas corpus. For personal freedom, habeas corpus में होता है. Supreme Court, supremacy of law, equality before law, and predominance of legal spirit are the basic principles of the doctrine of rule of law is the correct answer. So supremacy of law, equality before law, and predominance of legal spirit. इसके लिए you can also refer to AIBE rule of law. Okay, the three principles are given there. Then again, rule of law से question है. Rule of law is the antithesis of arbitrariness in all civilized societies. It has come to be regarded as a mark of a free society. It seeks to maintain the balance between the opposite notions of individual liberty and public order. This was opined by whom in the famous habeas corpus case. Again, questions like these will not be given in your barracks, and that is why you have to memorize it to some extent. इसका answer है A, and that is HR Khanna. I was not aware of this personally, so this is the first time even I am going through it. So we will remember that the answer over here is HR Khanna in case of rule of law case, जिसमें opposite notions की भी बात की गई थी. Then let's move forward. Maxim delegatus non potest delegare means. इसका आंसर है a delegate cannot further delegate. Consumer Protection Act 1986 is predominantly based on UN General Assembly resolution with due negotiations in the none of the above. The answer is none of the above. All the three options are incorrect. Which of the following is irrelevant fact under Evidence Act of 1872? Facts which make other relevant fact as highly probable. ठीक है, बिकॉज जो ये फैक्ट्स रिगार्डिंग मोटिव है वो रेलिवेंट है. फैक्ट्स रिगार्डिंग स्टेटमेंट्स विदाउट रिलेटेड conduct is also relevant. Facts regarding statements clubbed with conduct is also relevant. So the facts which make other relevant fact as highly probable, they are irrelevant facts according to the Indian Evidence Act. 36 है test of competency of witnesses capable of understanding the nature of the question and giving rational answer. ये बहुत सारे केस लॉज में भी upheld किया गया है. Which one is the exception of rule of hearsay evidence? Dying declaration. Then communication between husband and wife is treated as privileged communication if it was made during marriage, even without promise of confidentiality. 39. 39 says leading question can be asked even without permission of the court during cross examination. बाकी सब में नहीं allowed है. Leading questions are only allowed in case of cross examination. What do you mean by word evidence? Facts introduced in court of law. So that would become your evidence. Let us move on to 41. What is fact and issue? Fact and issue, necessary facts to arrive or determine rights and liabilities or immunity. So fact and issue, the answer over here is B, necessary facts to arrive or determine rights, liability or immunity. Relevant fact over here is facts legally relevant to any fact and issue. Legally relevant being the keyword. Logically relevant might seem logical, but the correct answer is legally relevant. So 42 का जो answer है वो है B. Then 43 says the term lockout under Industrial Dispute Act is defined in. This is option A. ये easily मिल जाएगा. We'll always carry the bare acts of the labor law. So in that you can easily refer this. The term layoff has been defined under the Industrial Dispute Act under section 2 triple K. Then 45, the Trade Union Act was enacted in the year 1926. See, I would advise you to check which all barracks are you buying, because a lot of times I've seen कि जो 20 barracks का वो मिल रहा like the 20 barracks combo which you're getting online, most of them don't have Companies Act and labor laws. तो Companies Act तो फिर भी I have not seen a lot of questions from that, बट लेबर लॉ में फिर भी काफी डायरेक्ट क्वेश्चंस आते हैं जिसके लिए बेयर एक्ट इज एसेंशियल. सो आई वुड सजेस्ट यू चेक वेदर यू हैव टेकन योर बेयर एक्ट्स फॉर योर labor laws. The term minimum wage has been described in the Minimum Wage Act. Then 47 was a wrong question, so इसमें grace marks मिल गए थे. The Trade Union Act provided for all of the above. Registration of trade union भी होता है, registration of trade union for workers भी होता है, recognition of registration of trade union as juristic persons भी होता है. Foreign court under section 25 of CPC means a court situated outside India, the authority of government of India. फिर judgment under section 29 means statement of grounds of an order or decree. Principle of res sub judice is provided in section 10 of CPC. Doctrine of res judicata as contained in section 11 of CPC is based on the maxim both A and B. Nemo debet ex vixari pro uno et diem causa as well as interest republicae ad sed finis litium. बहुत सारे क्वेश्चंस ऐसे भी होते हैं जिसका आंसर आपको डायरेक्टली नहीं मिलेगा, so you can just give a random guess because obviously negative marking नहीं है, so you have to make sure you have attempted all your questions. 53. 53 says principle of res judicata applies between co-defendants, between co-plaintiffs, both A and B or neither. Answer over here is neither A nor B. Validity of a foreign judgment can be challenged under section 13 of CPC in a civil court only. Under section 15 of CPC, every suit shall be instituted in the court of lowest grade. X residing in Delhi publishes statements defamatory to Y in Calcutta. Y can sue X at either Delhi or Calcutta. A suit for damages of breach of contract can be filed at a place where the contract was made, where the contract was to be performed, or breach occurred. ये दोनों सही options है. Anywhere in India is not correct. That is why your answer is D. In every plaint under section 26 of CPC, facts should be proved by, and your options are oral evidence, affidavit, document, oral evidence as well as document, even though D might seem tempting to tick, but the correct answer is affidavit. Which of the following is correct of a standard form contract? And the answer over here is A. It is a valid contract. As a general rule, an agreement made without consideration is void. A contingent agreement based on an impossible event under Section 36 is again void. The consensus ad idem means meeting of minds upon the same thing in the same sense. In famous Carlyle versus Carbolic Smoke Ball Company 1893, the Honorable Court held that the contract was accepted on being The answer over here is acted upon. Again ये चीजें नहीं मिलेगी वेयर एक्ट में, इसीलिए इसको मेमोराइज करना जरूरी है. In famous Carl versus Carbolic smoke ball case, the court held that the contract was accepted on being acted upon. Inadequacy of consideration does not make the contract void. A jus in personam means a right against a specific person. Exposure of goods by a shopkeeper is invitation to offer. Offer नहीं है, invitation to offer है. You should be very clear as to what is an invitation to offer and what is an offer. Again, even terms like counter offer, acceptance, ये सारी चीजें का general knowledge होना बहुत जरूरी है so that you don't waste time during the exam. An agreement to remain unmarried is void. ये agreement and restraint of marriage का section आ जाएगा. You will be able to find this in the Indian Contract Act. Agreement enforceable at law is a contract. An agreement shall be void for, ये जो question है इसका grace marks मिल गया था, ये गलत था. Void agreement signifies agreement not enforceable by law. क्योंकि valid agreement है, agreement enforceable by law. So some places you have to apply logic. A proposal when accepted becomes a promise under section 21B. Then 72 is offer under section 2A is, the option is C. Willingness to do or to abstain from doing an act in order to obtain the assent of the other thereto. Which of the following statement is incorrect? The answer over here is sahi hai. Specific relief act 1960. So see, now what has happened over here is this is a 2012 paper जिसमें 2019 का amendment obviously नहीं था. इसीलिए जो ये वाला क्वेश्चन है ये अभी तो आपसे पूछेंगे नहीं, क्योंकि स्टेट ऑफ जम्मू एंड कश्मीर बाय वर्च्यू ऑफ 2019 रीऑर्गेनाइजेशन एक्ट से वो include हो गया है, and therefore we don't need to attempt this question. Now let's move on to 74. Which of the following is correct? Both A and B are correct. Under Section 7, suit may be for recovery of special movable property in alternative for compensation. And under Section 8, pecuniary compensation is not adequate relief for the plaintiff for the loss of article, and relief paid by injunction restraining the defendant from disposing of the article, otherwise concealing and blah, blah, blah. So both the questions are correct. Then 75. The Transfer of Property Act 1882, unborn person acquires vested interest on transfer for his benefit under transfer of property upon being birth, upon his birth, sorry, upon being born or upon his birth. Then which Sellings Transfer of Property Act deals with section होगा ये, with section of Transfer of Property Act deals with onerous goods, and the answer over here is section 127 deals with onerous goods. Then 77, the Negotiable Instruments Act 1881 came into force on, the answer over here is section option C, that is 1st March 1882. Again, this is a very common thing. बहुत सारी acts जो year mention करती है अपने short title में, वो usually force में next year आती है. तो यहाँ पे even though options A and B seem correct, considering कि the year is same 1881 दिया है, but the right answer over here is 1882. So even though sometimes you might be having the bare act, but confidence में आप just 1881 mark करके आते हो, and you will lose on your marks for no good reason. So that is why जो direct questions होते हैं, make sure you at least check those questions from your bare act. जो नहीं दिया है bare act में, obviously we can't check it, but even if you're very confident about a certain answer, you have enough time, so please verify your answers, whichever are given directly from the bare act. 78. The term negotiable instrument is defined in the Negotiable Instrument Act 1881 under section 13 है right answer. Then the existence of statute of limitation are due to, ये all of the above है. Long dormant claims have more cruelty than justice in them. The defendant may have lost the evidence to dispute the stale claim. Persons with good causes of action should pursue with reasonable diligence. सब सही है. Limitation Act is applicable to civil suits only. Criminal law में नहीं applicable होता है. 81 is Upon failure to hold statutory meeting, the penalty of defaulting company shall be none of these. Free transferability of shares is mandatory in public limited company. Free transferability of shares is mandatory in public limited company. 83. The memorandum of association of a listed company shall be as per Table B. Companies Act को भी ले जाना I think is sensible even though there are few questions, but बहुत सारे ऐसे questions भी होते हैं जो आपको direct answers देते हैं and which you might not be able to remember. So if you probably don't have the act and if you've not purchased it yet and if your exam is very soon, I think you can also request for people who are around you to give you the बैरक for some time, but obviously exam के time पे इतना सारा chaos already होता है, so at that time it is always advisable to carry your books if you've given the opportunity to, right? Let us move on to 84. ये grace था, ये सही नहीं था. फिर in the IPC nothing is an offense which is done by a child under, this is 7 years. इसके साथ ही वो read about the provision which talks about children between 7 to 12 years. That's just given next to each other. Then right of private defense of body extends to voluntary causing death if the offense, if the okay, if which occasions the exercise of right. This is A. Reasonably causes apprehension that death will be caused. Under Section 498A, the cruelty means and includes both mental and physical torture. What is the offense where preparation itself of an offense is punishable? B. Dacoity. In Rex versus Govinda, the points of distinction between the two provisions of the IPC were explained, Section 299 and 300. A has sexual intercourse with his wife aged about 14 years with her consent. A has committed offense of rape because the age limit is mentioned in IPC, and even though she's given her consent, she's not reached the age, and therefore the right answer over here is offense of rape. So these are the questions, and the last 10 questions are missing in this set. So we will end here and we will move on to the next paper in the coming video, and that is going to be of the year 2013.